First of all, I want to thank FALA for having us here. We're very happy to come out and help educate all of us who are in this managed care village about how this is supposed to work and how it really works. As I said earlier, we have several ways that you can follow us and keep up to date. What we have tried to do is become somewhat of a clearinghouse of information. So we have an open line of communication with the Agency for Healthcare Administration as well as the Department of Elder Affairs, and we regularly get information from them and have them answer questions for us. We try to post that information on our Facebook page, our website, and again, here is our email address for questions. The foundation is made up of the three of us. I'm Twyla Sketchley, I'm in Tallahassee. Emma Hemness is in Brandon, and Rebecca Bell is in Port Richey. We are all board certified elder law attorneys, which means we are three of 96 elder law experts in the state of Florida. We have been working with the managed care issue since it became a policy fantasy several years ago through legislation and now through implementation. Between the three of us, we've put several thousand hours into reviewing regulations, waiver contracts, proposed legislation, policy briefs, rules, regulations, contracts, you name it, we've looked at it. What we do as a foundation, we provide training for providers and caregivers. We do consulting. We can help review contracts. We can help review grievance problems. We do fair hearing stuff. We help with long-term care plan development, case review and analysis, and legal expertise in fair hearing.
Anytime we're dealing with Medicaid, here's an illustration. This gentleman hiked long miles through the wilderness, and then he comes upon this sage sitting on top of a cliff, and the sage looks down at him and says, "Now, while I can explain the meaning of life to you, I don't dare try to explain how the Medicaid system works." So I figured that this would be appropriate for everybody who's had to deal with Medicaid at some point in their life. And essentially our presentation today is, if you're in the room, if you are a Medicaid provider or considering being a Medicaid provider under contract, then you will have this feeling at some point. We also wanted to provide you just the 2014 Medicaid financial criteria. We have the income cap rules up there. We have the Florida resource rules and a few of the excluded assets under the resource rules. Just a few bullet points there for your immediate review.
Okay, just to kind of give a overview of what we're going to be talking about this morning. Of course, the new Medicaid managed care program, it is divided into two components: the long-term care program, which we will mostly be focusing on today, and most of what you will be dealing with initially with your residents, and then the second component, the managed medical assistance program, which we will touch upon at the very end briefly. But of course, we are in the midst of the rollout of the long-term care component. But however, the managed medical assistance program is following soon thereafter. As you can see, I think our this area we're in here will be in June, I believe, so not too far out. So to understand the complexities then of combining the two. What is managed care? What is the difference between this new program and what you have been dealing with Medicaid before? The main difference is traditionally Medicaid, for the most part, has been a fee-for-service system, as you probably have dealt with Medicaid, where you were reimbursed directly from the state for services billed and services provided. Managed care, on the other hand, of course, it's involving the private plan. There's an extra party involved. You're contracting with the plan, and then the plan decides how and the manner in which services are delivered and enrolled with the residents. The managed care, it's also a component the way it works from the financing. Obviously, it has provider network management, utilization management, and quality assurance are some components of the managed care system. Like I said, the MCOs, as you have been in the midst of contracting with them, with your facilities, and then they offer the healthcare services to the enrollees. and are responsible for making sure that they have the health care services that they need. As we said, it's as opposed to the fee-for-service reimbursement system, it's a capitated arrangement where the plans are paid a fixed rate per enrollee that they have in their plans. Twyla touched upon the history of the program. It's probably very few know that it did start actually back in 2006 as a 5-county pilot project. So with very limited populations, there was not the long-term care component as part of it then, but it was mandatory enrollment for, again, limited populations in a 5-county area. When we became intimately involved in this was when in 2011, when the Florida legislature passed the legislation dictating that the state should basically expand statewide, and then virtually all Medicaid beneficiaries, including the long-term care services. And so there was a period of 2 years when Florida was submitting waiver applications to CMS. It required approval by CMS, the federal government, to approve the waivers, and there was multiple waivers dealing with the managed medical assistance program and also the long-term care component. And then, of course, in 2013, at the end of that was when the waivers were approved, and of course we're in the rollout now. Who is required to enroll? Of course, any of you that had been dealing with the ALE waiver or the nursing home diversion waiver, you understand that all of those residents, recipients are automatically enrolled in the program. Or I say automatically, there's still the choosing of the plan and so forth, but they would be all of these waivers listed here, including ICP clients that are in the nursing homes, would be part of this new program. And these waivers you will not see anymore in much of the procedures that dealt with these waivers. It is one big waiver now with kind of statewide, all one big component. For those that are going new into the system, that are just applying for Medicaid and so forth, the ones that will be required to enroll in the new Medicaid managed care system would be anyone that's 65 years of age or older, or age 18 or older and eligible for Medicaid by reason of a disability. And then also both categories would need to meet the nursing facility level of care done by CARES. But just a note here, as you probably will know, that it is not automatic. Nursing home remains an entitlement program. As long as you meet the requirements, you're in. However, that's of course not the case for ALF or home community-based programs. And we're going to be going more into that in detail, but that does remain subject to availability of funds. The wait list will continue. These are the services that are listed, much of what is provided at your ALF. These are the required services. There would be some additional benefits that plans, of course, have the option to offer, but these are the mandatory services that must be offered to those enrolled in the program.
One thing that the waiver does is it provides case management to all participants. That means that every person who is in the home and community, who is in an assisted living facility and in a nursing home, has an individual case manager who develops a case plan and works with that individual going forward. Some of you who may be from areas who've already enrolled may have experienced case managers coming in and evaluating your clients for an initial case plan. This case management is to oversee the care of the residents going forward, and it is to integrate services across the spectrum. Now, the provider network is what you all are part of, and that is the group of health and long-term care services that have contracted with a particular managed care organization to provide services to that plan's members. In the long-term care side, we've got nursing homes, assisted living facilities, hospices, home health, Meals on Wheels, a variety of providers. Now, the plan will pay you based on your contract rate. So if you have not already done so, you're in the process of contracting with the managed care organizations, and they will set the rates and requirements for you. The plan does not have to contract with everyone, and you don't have to contract with a provider or with a managed care organization. The plan can limit the number of providers so long as those providers can meet the needs of the members. And the plan authorizes all the services that are going to be provided to the recipient. This is ACA's interpretation of what this would look like. So the blue folks are the managed care organizations, and then you all are the little people actually doing the little work in the network. So I thought that was just adorable. Now, plans must offer a contract to any assisted living facility who billed for Medicaid services as of July 2012. The operative word is offer you a contract. You don't have to accept it, and you don't necessarily maybe like their contract terms, but by law they're required to offer a contract. Now, after the first year, the plan can eliminate assisted living facilities from their provider network for failing to meet performance and quality standards. The Agency for Healthcare Administration is trying to work with a task force to standardize those across the industry, because early on some plans had different quality standards than others. Now, one of the big things that is touted with this managed care waiver is that we are going to be putting more and more people into the community. This is what they call rebalancing. Now, managed care, the managed care companies are trying to facilitate transitioning folks out of the nursing home into assisted living facilities and to the community. The emphasis is on a home-like environment, and they think it can be done by increasing the coordinations of services through case management. Now, what they also are trying to do is get more of the residents involved in their care. The assumption being that if you involve more residents and they have more say in their care, they'll get better faster. Now, some of my clients still think Kennedy is president, and that may be a problem. There is also a component of the waiver that allows for the expansion of what is called the participant-directed option, which has not been fully implemented yet. The capitated rates are adjusted. Now, the managed care organizations have a financial incentive for pulling people out of the nursing homes. The capitated rates are adjusted annually to encourage plans to get people out of the nursing homes and into the community. In addition, if they meet certain rebalancing percentage goals, they're given a financial bonus. So at the end of the day, the goal is to shift currently what is a 35% of the nursing home population into the community over time. Now, there have been some studies that show that we really only can shift about 8% of our current nursing home population into the community safely. And that's a huge study that was done by Georgetown. There's also some writing by Kaiser Foundation that seems to support that. So as assisted living facilities, some of what my colleagues are going to address is some of your liability in taking some of these residents who may not be able to be dumped on you for bonuses for the managed care organizations, hence granny dumping for bonuses. And I'm going to turn this over to Rebecca.
Okay, so a little bit more on the rebalancing, just some considerations for you all as ALF administrators and so forth. The concern, of course, is that someone from the nursing home transitioned into the community to an ALF, that the ALF is able to meet their needs, of course. So, and that is going to be your responsibility. The liability is yours to determine that. So this is straight from the contract that the ALF administrator is responsible for determining whether the facility can meet the needs and for monitoring, not just initially, but then continuing to monitor the appropriateness of the placement. And then the person to contact if you, to see that that is not an appropriate setting at some point, to contact the plan, you know, because again, it all goes back to the case manager deciding the placement and where someone is moved from or to. The other element, this is, we're going to be, I think, touching upon this a little bit, also concerning the wait list we mentioned. You know, how to get on it, how to avoid it if possible, if someone needs to be in a facility, maybe not at the nursing home level, but they are there currently maybe for a rehab session, and but they need financially that assistance to pay for, you know, your ALF cost. One way to avoid being on that wait list and to go ahead and get that financial assistance and be on Medicaid is for them to be approved in the nursing home first, you know, under ICP. But they have to be there at least 60 days, which unfortunately with the DCF application timing nowadays is probably not much of an issue. But so it's really the crucial point is that ICP application from DCF needs to be approved first before they can transition to that ALF in order to go directly and stay on Medicaid. So just an important thing for those to understand and not to kind of rush the transition without that kind of procedural taking place to maintain that Medicaid eligibility. And again, this Trilo just touched upon this again, the financial incentive, just to make sure that you understand that is in place. Those are underlying factors. There's kind of what I kind of categorize as the short term and the long term, but again, that the plan is paid a certain rate that's set in the beginning of the year, and that rate is for that mix of nursing home versus community clients. So if they, during that year, move the resident to an ALF, they maintain that higher rate. So obviously more profits for the plan if they go ahead and move someone to the ALF or community and still get that rate until it's adjusted the next year. So, and then again, long-term, what the legislation that dictated of the 35% and kind of the incentives and financial bonuses that are provided to the plan for that rebalancing. Again, just to make sure it's the case manager employed by the plan that's ultimately going to be making those decisions, so to be aware of that.
What we want to reiterate again and again is the fact that the form of Medicaid that is available in the assisted living facility as well as in the home is a waiver, and it is not an entitlement. That's why you see the discrepancy between individuals going into the nursing home, having met the Medicaid criteria that we showed you earlier, they're going to be on Medicaid. But if an individual comes into your assisted living facility and you might have had this conversation with a family, how much money does our resident have? How long will, you do the math in your mind if you're an administrator. I mean, this is a business for you. And you try to figure out, okay, is this individual, how long is this individual going to be with me? And understand when the individual may run out of private pay funds. And let's just assume that they do not have the Veterans Administration benefit that a lot of people take advantage of. And so the unfortunate aspect is that we are limited to that individual who's now a resident of yours running out of money. It doesn't automatically make them eligible for Medicaid just because they have run out of money. So with it being a waiver, there is a waiting list and there is a total cap on individuals who may actually be able to partake in this version of Medicaid for in the home or at the assisted living facility. I think a number of individuals forget that aspect of it, and that's why what Rebecca was saying just a second ago is if you can have the individual get Medicaid eligibility in the nursing home, then the Medicaid follows them. That is not a technical term, but it's like the Medicaid follows them into your assisted living facility, and then you have, quote unquote, trumped the waiting list. The statistics that we've had recently is that there is a cap, the waiver required, the waiver that was approved by CMS, the long-term care waiver approved by CMS on February 1 of 2013. The cap for the next 5 years of individuals being able to enter into the program is 37,000. That is a cap on the total number of individuals that are allowed to enter into this program. And a ACA statistic is that there are now 36,000 currently using the program. Now, I went to law school. I did not go to math school. Okay, but I can take off my shoes and count on my toes, and I can figure this out. That's not a very wide margin. And then the Georgetown, which Twyla mentioned a little bit ago, the Georgetown presentation that was done a little while ago says that there are also 34,559 seniors on the wait list now. I'm going to read that number to you again. 34,000 seniors statewide waiting to access Medicaid. So again, what Rebecca said in the previous slide, if you get nursing home Medicaid coming to your facility, okay, very important. So if you have a resident now, what do? Okay, they're running out of money. I have actually heard rumors from my families who come in that say, well, the assisted living facility told us, well, wait until you're down to about 2 months worth of private pay left, and then we'll get Medicaid. Okay, the previous slide said that is not the way it works. So if you've got residents, communicate with them now, communicate with the families, get them on the waiting list now, because the waiting list process has changed recently throughout this implementation. The Department of Elder Affairs still controls the wait list, but they control it centrally out of Tallahassee. The AAAs, the ADRCs are the gatekeeper now exclusively, and there's a brand new 701S form. It used to be a 701A form. That is the telephone interview that occurs with the families. Do not wait, because your residents, even if they get on the wait list, they still have a priority or frailty ranking. So if they're super mobile, super good, they are going to be low, low, low. Because as soon as they leave the home and then come to your assisted living facility, believe it or not, your resident has just shot themselves in the foot, because they are no longer in danger of institutionalization if they're getting good care in your assisted living facility. So that itself, being in an assisted living facility instead of being in the home, is a lower priority ranking. Okay, so what I'm going to do now is I'm going to go through a couple slides on enrollment. This was a huge issue. One of the things that Twyla said at the very beginning is we actually are predominantly an advocacy organization for seniors, the consumers, your residents, the people you serve and take care of. And we also, what we've done over the last 3 years is we also lecture extensively to other elder law attorneys in the state of Florida. In fact, Twyla and I leave here today for an advanced course tomorrow in Orlando. 2 elder law attorneys. Twyla has presentation number 1 at 8 a.m. and I have presentation number 2 at 8:50 a.m. and we're talking about the same things we're talking about today. But the foundation created this LTC managed care rollout where it says, okay, when is the rollout dates? What are the counties involved? Where are their regions? And who are the plans in each one of those counties? Oops. Let me try that again. Okay. Who has to enroll? Well, we've already said it. On the LTC side, mandatory enrollment for every senior that is currently on Medicaid, as well as seniors who may in the future receive Medicaid. And the Medicaid we're talking about, I say this in my materials, not that you have today, but I say, remember that Medicaid is like ice cream. There are as many forms of Medicaid as there are Ben and Jerry's ice cream, flavors of Ben and Jerry's ice cream. So remember that. So every time we're talking about the institutional care programs, the long-term care programs, so everyone has had to enroll if they're a current recipient or are going to access the Medicaid institutional care benefits. So that's nursing home residents, assisted living, in-home care recipients. So these are individuals, again, applying for nursing home Medicaid, and then once upon a time, if you get lucky, then seniors who come up off the waiting list at some point when they're given an open slot. This is what your residents would have received. They would have received this brochure. That is, I should say, if you're in Region 6. Region 6 is consisting of Hardy, Highlands, Hillsborough, Manatee, and Polk. And I'm going to go to the next slide because that's the back side of it. So we have actually in Hillsborough, we actually had a choice of 5 plans. In Region 5, which is Pasco Pinellas, they had a choice of 4 plans. And so this is what your residents get to see. Now that just is clear as mud which plan to choose, right? Just amazing the way that works. And I don't know if you see some differentiation in the columns. There's a bunch of writing on some, and there's not so much writing on others. We did complain to ACA about that. We said, why does it appear that one plan offers so much more than the other plans? And that actually was a glitch, but ACA has yet to change the brochures because all plans under a model contract has to offer the same services. And so on this brochure, only the plan's extra services should have gone on there. That's not the way it appeared. Also, we do have some issue that has recently come up. I know we have representatives, and I'm going to say it exactly as we got it from ACA, straight from the horse's mouth. American Elder Care is not an option for auto enrollment in several regions of the state at this point in time. So what is ongoing with American Elder Care at this point in time is a senior, a resident of yours, who wants to enroll in American Elder Care can call the enrollment broker and can choose American Elder Care. However, when they get the welcome letter and it says if you do not choose by X date, then you will be automatically enrolled in, and then they had the little line where they had auto enrollment and they assigned the individual, American Elder Care is not allowed to pop up in those letters. And that is in regions, oh gosh, a whole bunch of regions. Okay, pretty much every region except 7, 8, 9, and 1.
2, right?
No, they are, that auto enrollment is not available in 2 and then on down the list. So just 1, 7, 8, and 9 because of some issues with payments to providers. Late payment to providers, getting behind, is the reason why American Elder Care is currently under a restriction. Okay, again, we're a senior advocacy organization. What we did is the problem we were seeing was there's all this complicated webinar material that ACA puts on. You know, you've attended a lot of these, you've attended those phone calls, and half the time you're wondering whether the person is actually speaking English on the other end of the phone. Or if you have a really, really great question, the person on the other end of the phone is, I'll take that back and we'll post it on our FAQ, and you may see it on our FAQ on our website. So you're not getting answers. And even if your answer was correct, like I was on a Region 11 a phone call with providers, and even though the correct billing code for a nursing home was 211, the plans didn't know that was the correct billing code, so kept rejecting the payments, or kept rejecting the payment to the providers. So on the senior side, we felt like nobody was consolidating the information, so we created a consumer brochure. And on our website, the foundation's website, it is super simple, easy to understand, and we basically boiled it down for a senior, their resident, their families. If they have a question, all you need to do is answer 2 questions. And when you answer 2 questions, then you know exactly what process follows next. So we called this our decision tree. You guys are going to be the orange and the green ones. And what Twyla said was, and if you're colorblind, that's the reason why we use the icons. You're the hat in the car, okay? So if you can't see orange and green, just remember you're the hat in the car. Because what it boils down to is, if you are in the home or assisted living facility, the senior just needs to say, all right, am I currently receiving Medicaid, or have I applied for Medicaid? And based upon either being in one of those 2 categories, then you can turn to the rest of the consumer guide, which is color-coded, and go through very simple, very easy to understand questions and answers. Now, why should providers give a darn about knowing a little bit about what the seniors will have to choose? And again, what I want to stress to you is, yes, we are in the process of rolling out. Yes, as of today, most of my clients, if they haven't selected, they're being auto-enrolled in Region 6. Region 5 is the same way. Why do you still want to know what seniors need to know, what choices or enrollment decisions seniors need to know? Well, it's because you're going to occasionally have a resident enter into the system, get up off the waiting list. And so they will have those questions at some point in the future. So you knowing what they would go through at that process is going to be the same as the current recipients of Medicaid in the diversion or ALE or the ADA going into the system for the first time. So communication with your residents, your families, puts you in a position of knowledge. It puts you in a position of value to them. That's very important so that you understand that. Also, you will want them to be, you want to communicate very effectively what plan you are a provider or part of a network under. Not all of you will be contracting with more than one plan. And so it will be important for the families to know that that's the plan they need to sign up for. Now, ACA says through the enrollment broker that those individuals, if they can discern that somebody's already part of a plan, then they will automatically be enrolled in that plan. But I don't leave that up to ACA to get everything correct 100% of the time. I think you're with me on that as well. Also, it's very important that you communicate with your families because you will have your contracts in place. You will want to know who's going to pay you, going to know what they're going to pay you. They're going to want to know how they are going to pay you, which I mean by either paper claims or computer claims, online claims. Don't go paper if you can at all avoid it. And when they are going to pay you. Remember, I already said we already have this one issue with payments to providers being delayed substantially enough that ACA put a restriction. And so keeping your families informed is very important. Now, what we wanted to go over is also they changed up the situation when one of your residents do come up off the waiting list. All right, so the new rules that apply here, so this is green, this is the car, this is all part of our consumer brochure where you can go to the website and download the entire consumer brochure. Your senior residents can do that as well. But there's a new process, and I want to tell you a little bit about what's going on because we're not happy about it because senior consumers sometimes are not getting the whole story. The new process for applying is they only can get, there's a new terminology called Medicaid pending. Medicaid pending to us used to be only related to nursing homes. Now there's a Medicaid pending terminology that is used with the assisted living facilities in home folks that are just coming into the system. There will not be, nothing will go anywhere until a complete Medicaid application with DCF is filed. Nothing will go anywhere if we do not have a complete level of care, which CARES still does, CARES. Now, when those two things occur, then it will trigger the enrollment broker to send a letter to the client, and that's when the plans, and that's when the client, your resident, will be able to select a plan. So that's the first time the plan ever enters onto the scene now. It used to be CARES would come out to an LOC, give some brochures to the client and say, pick a plan. And then the plan would be immediate. The plan would help with the Medicaid application, the filing of the Medicaid application. No, the plan is nowhere on the scene in the filing of the application these days. A plan has actually been told by ACA, you're not allowed to be in the process before the Medicaid application has been filed. So those are some significant new rules. Unfortunately, we got a hold of fortunately we did, unfortunately it was what it said, was the actual script that is used by the choice counselor. So this is a senior calling up saying, hey, I need to talk to you about selecting a plan. Unfortunately, the choice counseling script, when an individual wanted to begin services right away at your assisted living facility, they had selected the plan and they said, I want to begin services. The choice counseling script says, well, did you know you're going to be financially liable? Well, that's an actual true statement, but the problem is that they didn't say also, in addition to, do you know if your Medicaid's not approved, you're going to be financially liable? They did not also say, but the other half of the equation is, but if you do begin services begin immediately, And you have a reduction off of private pay at the assisted living facility because you're getting under the medical assistance portion of the Medicaid benefit. You guys are under contract. That's when you start getting your contracted rate with the plan. The unfortunate aspect is most people are waiting for services until financial approval, and with financial approval delayed from Department of Children and Families some 2 months, 3 months, that person is going to continue to have a private pay obligation to you. Maybe all have already run out of money, and so, but they're being told and scared, so to speak, with, well, if you begin services right away, you will be financially liable if the Medicaid is not approved. But if there's no question Medicaid's going to be approved, why wouldn't you select to begin the services? I hope I've explained that, but from a senior consumer standpoint, that's a big slant away from beginning services right away. That has some negative implications. Even if a Medicaid application was not approved, financially approved, then it is the plan who is responsible for the payment that came from the state of Florida. And the plan may, doesn't have to, but may seek reimbursement from your resident, but can only seek reimbursement for certain things. And these are discussed more in the consumer brochure.
Okay, and some of the issues, kind of what we call the transition issues, you know, someone that may be a resident who's not on a plan that you've contracted with. They've chosen another one for another reason, or not chosen a plan, or for whatever reason is in your facility. The transition rules in the model contract dictate that the plan must continue services. So sometimes this is more relevant for someone at home, but may be relevant for someone at ALF, that the plan must continue those services, whatever is in place at the time. So someone already on Medicaid and in the midst of this rollout, the plan must continue those services for up to 60 days, or until the enrollee receives the new assessment, plan of care developed, or the services are arranged and authorized with the new plan. So this, as a provider, important for you to know what might need to be continued. The scenario, let's see, let me go to the next. In terms of you as the provider with someone not enrolled to plan, again, that you have to provide those services until you receive otherwise instructions from the plan. The plan is required to pay you even if you don't have a contract. So in order, they're trying to kind of maintain that, continue that continuity of care to that Medicaid recipient. It is supposed to be at your current rate. So even if you don't have a contract with that plan, and that or you know it's a different contract rate, it is whatever the current rate that you're paying for those services. It would be similar situation for someone who loses eligibility for up to 60 days. So they were eligible for some reason. Frequent scenario these days is that something doesn't get submitted to DCF or was submitted and DCF doesn't have record of it. There's a lot of paperwork being lost these days. So potentially they may lose eligibility for something like that. The services must be continued, again, for up to 60 days. And then also something to note for a new enrollee, once someone is enrolled in the plan, that they must complete, for someone at an ALF, they must complete a care plan within 5 days of that person being enrolled in the new plan. Again, going into, in terms of maintaining those services, the plans have no requirements to give a certain amount of notice to stop providing services. It could be 1 day, so be on your toes and be watching out for those notifications. And again, what we talked about, potentially, you know, payment issues may be on the horizon. You know, Emma mentioned about the one plan being restricted by ACA. That was American Elder Care currently. So potentially some payment issues, just to make sure you're educated with who to contact if there's problems with that. And again, Emma mentioned about maybe electronic claims being more beneficial than paper claims.
So essentially, what we're trying to establish is protect yourself as a provider. So before you provide any services, check. While you provide services, check all the time. And because ACA has placed the responsibility on you to make sure that the resident for whom you're working with, that they are currently eligible for Medicaid, as well as the services that you are rendering to them are the prescribed services that you have been given the approval to provide. So this is down towards the bottom there is a checklist. And so I underline number 5, do you have authorization from the LTC plan prior to rendering services? What we have recommended is that when you go into the verification system, that you print when you see that the person, your resident, is Medicaid approved. Make sure you print out that screenshot, write down, keep a good log, write down when you did it to the exact time of the day and what the date was, because that will save you later on. So make sure that you check, double check, check again, train your employees to make sure that they print out and have proof of what they saw and not their word against somebody else's word. The last thing I would touch on in this section is we've been tracking the number of program implementation pitfalls. There's been so many of them. My client got enrolled in September, even though they live in Tampa, and we're not even rolled out yet, but they were enrolled in September. And so, in this case, it was a nursing home, and the nursing home wasn't getting paid anymore because the plan was receiving the payment instead. So, and to try to undo that, we were told, you got to call the Department of Children and Families, and you got to call the call center line. All right, how many love calling the call center line? And those people are so friendly, and they're very smart too. So anyway, actually, I've got to tell you, I had one actually hang up on me because I was so frustrated, and it was coming through. I apologize. But anyway, premature enrollment, I just mentioned. Plan switcheroo, that was going on in Region 7, Orlando, that first rolled out what we call plan switcheroo. Somebody actually got their stuff together, called the enrollment broker, got on a plan, then when the welcome letter came or the confirmation letter came, they had been switcherooed. They're in a totally different plan than the one they chose. So we've had a number of those. Now plan payments, I told you, to providers, the wrong billing codes, which are actually the right billing codes, but yet you don't get paid no matter what. Please understand that if ACA has told you one thing, and you've gotten it from ACA, but the plan is telling you something else, the plan's going to be wrong. So you got to take it up with ACA, and we'll tell you how to take it up with ACA. It's because you've got to understand, if ACA has told you something, then go with that, and then just try to work it out. Again, we said paper versus electronic. So yes, and dead people have been enrolled too. So just wanted to let you know that.
And dead people are the easiest to provide services for. I am going to talk about making decisions for another person because I'm sure every person in your facility is perfectly competent to make really good decisions. So this should not be a problem for anyone. Okay, so who can make decisions for someone else? Now, I have a little cheat sheet out on the foundation table in the other room that has a list for easy reference of the variety of different legal relationships one can have and what statute they're under if you want to pick that up. That will help you in your analysis of when families don't tell you the truth. You probably don't have that problem either. Okay, an agent using a durable power of attorney may be able to make a decision. A healthcare surrogate or healthcare proxy under Chapter 765 can always make the decision. And a guardian of the person can always make the decision. A plenary guardian, that means you're the guardian of everything, you are the boss of everything. A guardian advocate for a person with developmental disabilities. Optionally available now under this waiver are adults with developmental disabilities can enroll. So you may come in contact with this. And then the designated representative for selecting a managed care plan, which we're going to get to in a second because that's ACA's solution to not having any of these things. All right, so the decisions to be made on behalf of your resident if they can't do it themselves. Choose a managed care plan. Choose when to enroll in all that enrollment stuff we just talked about. Choose the residential setting in which they live, meaning are they going to live in a nursing home? Are they going to live in an assisted living facility? Or are they going to transition back home or to a child's home? They can choose the providers like the doctors and home health agencies, etc. They get to participate in the care plan development, which we have found some of our managed care plans throughout the state are not honoring that. And they also get to decide when and how to file a grievance or a fair hearing. Now, choosing a plan. Consumers can choose themselves if they're capable to do so. I know that some people think it's just easier to have that slow-talking, hard-of-hearing, nearly blind, gray-haired old lady not make her own decisions, but guess what? If she's competent, she gets to, even if it takes somebody on the other end of the line 4 hours to help her. It serves them right for making her wait on hold for 45 minutes. The consumer can actually designate someone using ACA's form. ACA has created a form to designate someone to choose a plan for you. So why is this? Well, because their current system for analyzing all the documents that you can submit to them is completely and utterly consumer unfriendly in every way. So they created this form. It can only be signed if they're competent. So if they're not competent, an alternate decision maker can choose. So this is the form. You can find it on their website. There's actually a link, state Medicaid if you go to the ACA website under the Medicaid, it's a big link. You cannot miss it unless, well, you could miss it, but it would be really hard. I think they could see it from the space station. Okay, so the competent person has to fill this out and have it signed and witnessed and designate someone to make the decision. You then can fax it to this 850 number. You can email it, or you can actually send it snail mail and pray it gets there.
What is that phone number?
The form number, I don't know that it's got a form number. It is called the designation of authorized representative for selection of managed care plan. It actually may be on, these slides are going to be available, by the way, on our website. It may be on the bottom, but I can't read it.
They do move it around on the ACA
Yeah.
website, so you might have a great link one day, and what happened is it disappeared the other day when we tried to find it again.
Yeah, that's called link erosion. Other documents, and this is where ACA's system, as much as they have tried, does not function well. You can send your durable power of attorney, your healthcare surrogate designation, your letters of guardianship. Just as a side note, if a family member comes to you and says, I'm a guardian, and you want them to prove it, you say, please give me your letters of guardianship. If they don't have letters of guardianship in Florida, they're not guardian, period, end of discussion. Or the healthcare proxy confirmation form. This is not actually a legal form in any way. It's not a government form. Many providers have created their own with their own in-house counsel or copied another form or another provider's. And basically it has the child who's making healthcare decisions for that person in your facility sign that they're confirming that they're the healthcare proxy. So you can fax these to ACA, you can email them, you can mail them. And hopefully someone will actually look at them. You will not get a confirmation that they've received it. And then you get to call and choose by phone. And your choice counselors are available. Of course, you have to hope that that choice counselor can find in the file one of those documents you just saw. Now, I'm not a betting woman, but I'm guessing 9 times out of 10 that's a little bit difficult. So you can choose online, and this is a screenshot of what comes up when you choose online, and you can put in there your role. Now the problem becomes, what if you as a provider goes in and help somebody make a decision, and then their daughter, who is the actual legal guardian or the healthcare surrogate or the power of attorney, makes the decision. So communication is essential, and only as a last resort, and I mean dead last resort, should you be choosing. Program pitfalls, again, the enrollment broker failing or refusing to recognize alternate decision makers, because again, these people get hundreds of calls. Their training is not always, you know, they may have fallen asleep during their training. This happens to us all. Managed care representatives, we have many cases where the care managers have proceeded with care plans with someone who speaks in word salad and has a guardian, except that guardian wasn't there. So that whole thing about letting someone participate is meaningless unless you've got their legal representative there. The other problem we have is DCF, because there is in the ACA system, they designate they let the designated representative for the Medicaid application choose. Well, I have a couple of clients whose designated representative is dead. And so DCF, we've changed it several times with their change forms. They just refuse to recognize it because of some glitch in their system. So we can have the dead representative choose, I guess. I'm working on that one. As soon as I have it figured out, I'll let you know. If for all else fails, ask for an in-person meeting. You can call, you can have your resident have an in-person choice counseling meeting. And you cannot be denied that. So if there are problems enrolling, if your family is having problems enrolling, have them request that in-person meeting at a convenient time for your family member and resident. And I'm going to turn it over to Rebecca, who's going to talk to us about complaining.
So we know there would be no reason to complain about anything, but just in case, we have the first thing I wanted to go over. Well, this is the on the ACA website. You're probably familiar with this screen, but there, the purple, violet, whatever you call it, the button is the report a complaint. So that's one way, if you do have an issue, to go right online and go through. The next screen here is what you will see, what you have to fill out. You can, it's various persons, that whether your family, yourself, the resident, if they're competent, can go through, and any number of things. This is not to be confused with a grievance. The complaint is supposed to be addressed within, forget the time period, it's 24 hours, it's a very short time period. However, it's not probably as widely known that they do have the option, if they think it's too difficult of an issue, they roll it into the grievance system, which has much longer time periods to respond to. So it's, don't necessarily have the unreasonable expectation to get a response within a short time period. The next, something probably initially you might run into, at least, or your residents, if they, as you well know, once a plan is chosen and after the time period that you have to change, you are locked in after 90 days after that. However, there are some exceptions to that, and it would fall under a good cause reason. The good cause reasons do come from the Florida Administrative Code. There's a list of them that would have to be followed. Some of the examples are here that are listed. I do have the link to, I do have one thing I want to say. Some of the forms we've alluded to, the outline that I did submit for credit, to make sure you all got your credit for this presentation. I do have hard copies of that outline if you're interested in kind of more in-depth information. Or you have trouble sleeping at night, you want to read through it. We do have it at our table in the next room. But it would also have some of the links to some of the, the 701 forms we've talked about, or the healthcare, so those would have those links in that outline. And also attached was that exhibit, the full Florida Administrative Code of the list of good cause reasons. But again, some of these are some of the things that might be necessary. Again, kind of knowing that the care managers who are determining the services and the plans are hired, are employed by the plans. There's not necessarily as such as other programs that have rolled out across the country that are required to have conflict-free case management. That's not the case in Florida. So you, again, just kind of think about that incentive there that the case managers have in terms of the quality and amount of services. In terms of if you have a resident that does think they may have a good cause reason to change plans after the 90 days, you can call the choice counselor. A warning that, again, as Emma referred to, that we have reviewed the choice counseling script on these different issues, and there is a concern that we've read through that those might not be necessarily processed the right way, or the person you're speaking to may not have the knowledge of really assessing what a good cause reason is, and to make sure that ACA is required, and the appropriate persons that have knowledge on what good cause are the ones required to kind of make that decision. It shouldn't be just that choice counselor on the other line. So if there is a denial and that does not, that seems unreasonable, you want to make sure that you have written notice, that just kind of the due process requirements are preserved there, and that there are appeal rights if someone gets denied a good cause reason and may need to appeal that potentially through a Medicare fair hearing. Just some examples, I listed those, but just kind of something that might apply to you, that there is a move, whether of the plans have moved out of the system or a resident has moved and so forth. Another, again, on the service side, a delay in having a visit from the case manager. They're not getting services that they were required to get under the Medicaid Managed Care Program. The other type, similar again, the services. The other type of, for your residents, the type of complaints or kind of more now getting into the grievance side, if they're unhappy with the change type of services. They do have two options, and this kind of basically parallels through any issue they have. There is, the system within the plan that they can go through, but at the same time can always go to a fair hearing with DCF, and there's different time periods. They are supposed to be, they're required by the plans to be given these notices, but we have, again, concerns that those appeal rights and so forth and the correct time periods are, given to, at the appropriate times, to the enrollees. So it's important to make sure you know that. You should have provider handbooks that should have this information too, so if a resident is questioning what they need to do when and where, that it should be located there. But we're providing you kind of that information too, so that you have that for your residents. There is an expedited appeal process if there is some type of service that would be detrimental to their health. There is that expedited. There is supposed to be that 72 hours of receiving that appeal. The other issue, if there's an element that if they've been denied some type of service, there is a way to make sure through the during the appeal process that they are continuing those services. However, again, you have to have, there's certain time limits for that, and they need to actively request that those benefits be extended. They can't just file the appeal agreements and that be a given, assumed. They must actually request that those services be continued. These are the different ways for your resident if they have an issue or their representative that needs to file a fair hearing. There's multiple different ways. It can be oral and writing. We, of course, recommend that it would be in writing, but that's requested to make sure you have proof of the time periods being met. And then if it's other than denial or something to do with a change in the level of services, something that they're not getting along with their case manager or any type of conflict with that, again, that would be you file that complaint referring to that button. If it's not addressed within that time period, you do have the grievance, again, can be written or oral, and that has to be within 1 year of the occurrence, or again, the fair hearing within 90 days. And just to note too that at some point if they've gone through the plan process and they're not happy with the result, they've gone through the plan appeal process, they can still go back to the fair hearing at that point. Again, and that's what I'm referring to, they should get a notice resolution, and that's what I was just saying, you can go through the Medicaid fair hearing process at that point, or still go through the plans, what they call the Beneficiary Assistance Program. Now getting to something more kind of close to home for you all, this is dictated in the model contract, of course, how complaints need to be made by you as providers. Again, that you should have a provider handbook provided. You can request this if it hasn't been provided. Some, I think, plans have it available on their websites. However, you can request a hard copy just as easy reference. You should have a toll-free helpline with that plan for any issues. And any aspect of, administrative functions, claims, billing disputes, service authorizations, I'm sure you will have none, so you will have no use for this, but just in case that should be available to you as providers. And also note that the scenario where we talked about that you may have a resident, on a plan that you have not contracted with, these policies and procedures would still apply to you. The time period, so if you do have a complaint of issues that must be within 45 days, and then the plan must notify you within 3 business days of that receipt, that they've acknowledged they have received your complaint. And then also kind of an expected, date of resolution, so you know when to follow up if you haven't heard anything. And then lastly, if it's unresolved after 15 days, the options to then know that all those complaints has to be resolved within 90 days, and provide that written notice and so forth. And I'm going to turn it back over to Twyla for the residents' rights.
And I want to add that complaint button that we talked about at the beginning. You can also, as providers, put your complaints in there. ACA is required by CMS, Center for Medicare and Medicaid Services, as part of this waiver, to track all the complaints. And that complaint button is how they are tracking it. So if you complain to the plan is supposed to report complaints to ACA, but human error sometimes leaves out information or reclassifies what you considered a complaint. So if you have a complaint, even if you're following your provider stuff, make sure you complain on that button so that ACA can see what the problem is, because we're all in this together, the plans, us, our clients, and if we don't know what the problems are, they cannot be fixed. So, all right, I'm going to talk about residents' rights because I heard a very disturbing myth that residents' rights no longer apply to assisted living facilities that are now accepting the waiver. I actually had somebody tell me that. So, let me clarify. The residents in your facilities all get their residents' rights, okay? 2 in particular that are going to be significantly impacted by the waiver because of this myth that the residents' rights don't apply are I just want to make sure that you all understand that regardless of a managed care organization's decision about where residents goes and how, you still have to adhere to the policies about your residents' rights, including discharge. The 2 big problems we're going to see are adequate and appropriate health care consistent with established and recognized standards. Earlier we talked about how it is your obligation and will still continue to be your obligation to evaluate that resident to determine if their acuity level is appropriate for your facility. They're entitled to be in a facility that can provide their care. So if you happen to have a case manager that wants to keep someone in your facility who cannot be there, you have an obligation to go through your discharge process and have that person put in a safe place. Now, let's say on the other side you have someone who the managed care company wants to be moved like that. Guess what? You are still obligated to provide appropriate notice. If you're assisted family care home, you get 30 days notice. You have to give them 30 days notice in writing. And if you're an ALF, it's 45 days, and you still have to send it to the resident, their representative, and the long-term care ombudsman's office, except when a relocation is for an emergency. For instance, you have a resident who has a massive stroke and you need them to go to the ER and they can't come back, or I once had a little old lady who beat up her competition over a man in a facility. She had to be taken out right away. Now, when you are dealing with residents with the waiver, because of the financial incentives that our state legislature has put on the managed care organizations and the mandatory transitioning that has been put on our managed care organizations, you guys have to understand you need to be selective up front, okay? Because you could very well have someone dumped into your facility that might be okay for a month, and then they're not gonna be. And you may have to fight to have them transitioned back out to a nursing home, and we saw that in the diversion quite a lot. Unlike the diversion, the managed care companies can't tell you to disenroll in diversion and get on ICP, because once you're in this. So, you have to evaluate the client, even if the MCO's case manager says we want them to stay. Now, the other thing you have to be worried about is the folks being too poor to be on Medicaid. This is when someone is coming to your facility from a nursing home and your room and board is, let's say, $1,500, so I can do some easy math, and their Social Security is the only thing they have, and they have $1,000. Well, Medicaid does not allow payment of Medicaid dollars for room and board, only for medical level of care. So you may be getting a resident that can't pay your room and board. How is that going to be paid? Now, if they are a veteran or the spouse or a widow of a veteran, they may qualify for veterans benefits. But if you take this resident, how are they going to pay? And their family may not be willing to be a responsible party. But once they're in that facility, now you've got the whole keeping them for free for 45 days, you know, that whole thing. All right, I'm going to turn this over to Emma.
Okay, we have good news and we have bad news. Good news is our presentation is getting towards the end, okay? The bad news is just when you thought it was safe to go into the water. Okay, you are going to be going through the LTC portion very soon, if you're not already, February 1 and March 1, predominantly in our particular area, geographic area, Tampa Bay, and then to the north, March 1 up in the other counties. But now, just when you got over the process with your families and gave them great information and prove yourself to be a very knowledgeable source of information, we've got the MMA implementation coming, the second stage of this big waiver. And so you're going to get to do it all over again. So the managed medical assistance is the second half. Your residents will, again, your seniors on the LTC will have to choose also an MMA in a number of circumstances if they do not have other creditable coverage. Now, I do not know of an example of creditable coverage other than I know that ACA represented that TRICARE would be creditable coverage, and so that your senior would not have to select an MMA. But Region 5 and Region 6, the rollout is June 1. We don't even get a full year to breathe. We have only a few months to breathe. And the first regions that come is going to come on May 1. And so all of the long-term care plans that the seniors may have already enrolled in through the LTC component or program implementation, they will be able to be selected as the MMA. That's the good news. Okay, so if they're already in an LTC plan, then they could just select that same plan and be part of their medical or their health insurance side in addition to their Medicare, except for American Elder Care. American Elder Care is not an MMA plan, so if you're in an assisted living, if you're the assisted living facility that only has a contract with American Elder Care, your residents will have to choose someone other than American Elder Care if they're the long-term care plan. We created a chart so you can see probably very small print there, but May 1 and May 1 is 3, 4, and I think 2, and then us, as I said, we are June 1. So most of our regions are June 1. Interestingly enough, Orlando, that rolled out on August 1 last year, have a full year. They're rolling out in August. next year. So the managed medical assistance services, we have a chart here of those items. Think just regular health insurance for anyone. Think that's what's getting covered under the MMA. And then we have also a chart here of additional or expanded benefits. They also have some specialty plans, HIV plan in particular, diabetes plan. Those will be things that a senior maybe, and some unique set of circumstances, may want to actually choose one of the specialty plans. ACA is just now beginning their webinar series to try to advise people that this is coming, but again, we're already telling you it's coming. And our final topic of conversation.
This is just come up in the last few days. As many of you may actually have received a very delightful email from a self-attested Medicaid planner about this very issue. We know because we've gotten dozens of calls about it. So let me clarify for you if you happen to have heard this rumor that you can no longer talk about Medicaid eligibility. Okay, that's not true, just flat out not true. What has happened is the Florida Bar's Standing Committee on the Unlicensed Practice of Law has issued a proposed formal advisory opinion. This is based on over a year's investigation into what started 2 years ago with a formal request by the Elder Law section of the Florida Bar to stop non-attorneys from doing what the law says non-attorneys aren't supposed to do. We have well, the document has been out on the Florida Bar website and advertised in compliance with the rules of the Supreme Court for the past 30 days. It was supposed to be, or it can be now, filed with the Florida Supreme Court as of yesterday. I don't know if it was docketed yesterday. It is a 22-page opinion with 350 pages of supporting testimony of non-attorneys causing significant harm to elderly and ultimately providers by giving legal advice and drafting legal documents, which has been prohibited by Florida law for a very long time, and people go to jail because it's a third-degree felony. Unfortunately, because federal law allows non-attorneys to file Medicaid applications, many people just assumed that meant you could tell people how to transfer assets and move income and purchase inappropriate financial products, etc., to the detriment of elderly people. Last year in Tampa, the Florida Bar, after several weeks of advertising, held a public meeting. Many elder law attorneys came, clients came, a couple of geriatric care managers, and the woman who may have sent all of you an email also came. The bar took testimony. They took several months of written testimony. There are several hundred pages of that written testimony that have been published on the Florida Bar website and have been there for months. So this is not a new, surprising thing. So what does this opinion do? First of all, the opinion does not prohibit the discussion of Medicaid eligibility. You can discuss with your residents Medicaid eligibility criteria, both income and asset. What you cannot do unless you are a licensed attorney in the state of Florida who has a relationship with that client, you cannot give them legal advice about what they should be doing with their assets and income to make themselves eligible, and you cannot draft legal documents for them. This is long-standing law. There are actually people who have been prosecuted for doing this in other industries who have drafted powers of attorney, trusts, and a number of other things that happen in Medicaid planning. You cannot do that. If you are working with a resident, you can say, you're not eligible for Medicaid, you need to go see somebody. Now, many facilities have been referring to a lot of non-attorney Medicaid planners because they tell you that it is much cheaper to go to a non-attorney than it is for an attorney. I've seen the contracts for non-attorney Medicaid planners. Now, I'm specialized. I'm one of 96 specialists in the state of Florida. One of those contracts I currently have on my desk bills a client 4 times my rate to do what I do, and that person had their insurance license revoked for preying on the elderly. And yes, that's part of the testimony if you just want to go through and read all that stuff. So that's what that opinion does. It does not change law. It does not prevent you from talking about Medicaid. It does not prevent you from helping someone submit a Medicaid application. It does not help you, or it does not prevent you from helping someone accumulate in that pile all the documents that need to be submitted. It just prevents you from practicing law, which you shouldn't be doing anyway, even if it's not a third-degree felony, because mean people like me will sue you for that. And it prohibits you from drafting legal documents because, again, you shouldn't be doing that anyway, because if you did something wrong, guess what? Mean people like me are going to sue you. So that's what the opinion does. That's it. Nothing new. It's not earth-shattering. Everybody who is a good person has been doing this in compliance with the law all along. It's the people who haven't been complying with the law. It's now very clear in that opinion so that prosecutors around the state can pull that opinion and say, oh yeah, that's pretty clear. You can't do that. Oh yeah, arrest them, please. So I have a question right here in the front.
This has been a hot topic down in Palm Beach.
Oh, I'm sure it has, because that's where the email came from.
And I was actually talking with Jaime, who's the CEO at our area agency on aging, and how the overall picture of dealing with the lower income people that are trying to move through the Medicaid process, in the event that you were to have someone that were maybe $23 over the limit, and there's really no big shifting of things, but yet some of the broad strokes appear, and I'm not an attorney by any stretch of the imagination, some of the language just appears to have a broad stroke about gathering financial documents and things like that. So you're saying that you can do that?
You can gather documents for submitting the Medicaid application. What you cannot do, and have never been allowed to do, let's make this clear, even though there are many people in our state that have, you've never been allowed, as a non-attorney, to get those persons' documents and say, based on the facts that you've given me, this is what you need to do under the law to become eligible for Medicaid. That is a third-degree felony.
Here again, I'm learning, because I've heard that in my area, apparently, the quit forms, the banks are handing them out, so that I've heard that some people who are not lawyers have been executing those documents. And clearly
And
that's in
that
violation
has
of the
never
law.
been allowed.
Okay.
That has never been allowed. You cannot draft, and we have some very well-meaning people in nursing homes that hand these out, and you cannot do that. And here's a really good example of why. Everybody says, oh, you're over income. You need a QIT. Oh, here's a form. Guess what? Let's assume that person has VA benefits, aid and attendance. Part of that income is not actually income under the law. And if you make them do a QIT and they screw it up, you've, one, committed the practice of law, and two, if it's screwed up, DCF isn't going to look beyond that QIT to see they didn't need one. They're just going to deny them Medicaid benefits, which as providers puts you all in trouble. But guess what? You're still going to try to discharge that resident even though you screwed up.
And you just used the language saying having a relationship with, as a lawyer, having a relationship
Yes.
with that client. How does this impact the overall picture of larger entities, be it a nursing home or a hospice, who has an attorney that works for them who executes these documents? How do you designate a personal relationship with them?
Well, and there are two different things. From the unlicensed practice of law stance and from the risk management, because I do risk management assessment, okay? First of all, any entity whose general counsel is drafting legal documents for someone who may have questionable capacity needs to say, I want to be sued and write a really big check. That's what you're doing. just from a risk management point of view. I do lots of litigation and we look for a deep pocket, and guess what? This deep pocket isn't protected by tort reform, okay? So if you are working and your general counsel is a well-meaning person and your entity is saying to, because this is how we see it. We see usually general counsel or something who sends the form to the facility. The facility gets the individual to sign it. Who's instructing them on how to set it up, what income goes into it, spouse money coming out, etc., right? So here's what the rules regulating the Florida bar say. These are the rules the lawyers have to adhere to. This isn't new. This isn't earth-shattering. When you got your bar license, you swore you read these and knew these. So this is the rule. If you're an attorney, you have to establish a relationship with somebody, and that relationship has to be conflict-free. So, as an elder law attorney, a client comes to me, I sit down with them, and I'm going to use you in the front as an example because you're listening attentively, not because I don't like you. So she comes into my office and she says, I need a QIT for my husband. Okay, I sit down, I look at her income, I give her the reason she needs it, or if she doesn't, why she doesn't. I then draft the document. I have assessed whether or not she has, one, the legal capacity to do this, and two, whether or not she is the legal person who can sign this document for her husband in the nursing home. I executed, or she executed with me and my staff, even we may go to the nursing home, so that we know she's done it. Now, that's required of me. I have to establish that relationship. If I'm charging, she has to pay me. If the nursing home is paying me, which I have had nursing homes ask if they can pay, I have to tell her that a third party is paying and get her to agree, because I'm in an attorney-client relationship with her. Now, if I'm general counsel for one of your entities, she's not my client. The entity is my client. And where does my loyalty lie? Am I really going to help her other than to make sure my facility gets paid? No. And I may give her bad legal advice. We've had out-of-state general counsels do this. So the relationship is, according to the opinion, which is not new, it merely reiterates the rules that all attorneys live by. It says if we're drafting legal documents for an individual, I have to establish that relationship with that individual. I cannot take direction from someone and who is going to come to me and say, you need to draft this QIT and this personal service contract and this power of attorney for this little old lady in this nursing home. Give them to me. I'm going to give you a check from the money she paid me, and I'm going to go get them executed. I can't do that. As a lawyer, I can lose my license for that. If I am not licensed in the state of Florida, I can have a UPL complaint filed against me.
Just a quick question. On the website, sometimes there's these templates, living will, power of attorney, healthcare surrogates. Just a general template.
Mm-hmm.
It's a Word document. Can you print it? And somebody says, where do I get a living will? Do you have a sample, whatever? Can we hand that to them, or no? We have to come check with your attorney?
I would ask your risk manager if that would be wise and how much insurance you've got to cover any screw up.
Well, you're a risk manager. What's your opinion?
Well, I can't give you legal advice. I would tell I tell everybody, if you've got a form and you hand it to them, you're in trouble, don't do it. Just assume, because even if you're well-meaning, here's the problem. Our clients screw stuff up, right? I mean, my clients screw up pretty regularly despite my directions. And I'm sure you've got residents who do the same thing. But when the bad stuff hits the fan, guess who they're blaming? Us, not themselves. So I say don't hand out forms, because that's just putting a big sign that says, please sue me when something goes wrong. Okay, I've got one here and then one here.
I might be wrong, but has anybody else been on the APTA site and found power of attorney forms and all of that stuff as part of what you have to or are supposed to offer in your admission.
They have
And they-
living wills and healthcare surrogates. They should not have a power of attorney. And if it's ACA forms and it's required by law to be in your packet, then it's required by law to be in your packet and you need to put it in there. I don't think there's a power of attorney in that packet. And if you're using form powers of attorney that you've had laying around your office for a while, I can assure you that as of now, they probably don't really allow somebody to do a QIT because we dramatically changed those requirements 3 years ago now. And all of the forms that I see that are handed out and printed off the internet are all wrong, so you can't actually establish a QIT with them. And then I had this gentleman over here.
My question was her question.
Okay, so we got your question answered, and then I got one in the front. You, ma'am, yes.
Could a facility, i.e. a skilled facility, make a direct referral from QIT to a particular entity or a particular lawyer, I should say?
What I recommend when I'm telling people is, one, don't refer them to non-attorney Medicaid planners because that's a legal document, and yes, I know that there are some facilities who actually have contracts with non-attorney Medicaid planners to do this stuff. No, don't refer them to non-attorneys. You can refer them to attorneys, but I would suggest that you have more than one, just so that you've got a variety so nobody can accuse you of doing whatever bad thing they come up with. If you want a quick reference on good attorneys you should refer to, who know this stuff and can get it done right, go to the Florida Bar, pull up the 96 attorneys across the state who are Florida Bar Board certified and hand them that list. It's easy, you didn't do anything, and you gave them a list of experts. And they can't complain because you gave them the list the Florida Bar says are experts in this.
Okay, so I guess we
she's got
probably,
We'll
I guess
get
we
one
can
more.
take one more question, and then this is the end of our presentation,
Yes.
so you will be able to go eat lunch.
And we're only 15 minutes behind now.
You have a resident that has a qualified income trust, and she has just VA aid and attendance going into that qualified income trust. Is that considered income for purposes of determining her resident responsibility in our facility?
That is a question that you need to send her to an attorney to answer.
That is a good question because there is, even within the state of Florida, there is discrepancy with DCF caseworkers as to whether the aid and attendance benefit is or is not treated as income. Then there's another discrepancy that only a portion of it is treated as income. And if it is not treated as income and you know it's not treated as income, it would be wrong, bad legal advice to actually put it in the qualified income trust because that should not be counted as patient responsibility. It should be off the radar of any plan. It should not be counted, and that person could then use that to pay a private room differential. So it is very complicated when dealing with the VA benefits to know exactly what's going on, know your caseworkers on how they're going to rule, get the appropriate documentation directly from the Department of Veterans Affairs out of Philadelphia. Philadelphia is our PMC, Pension Management Center. Have it broken down, and then be able to adequately, that the attorney be able to adequately say, do you need a qualified income trust or not? So in some cases, there is no need for a qualified income trust. There's no need to pay me for one when I can determine it's outside accountable income. It's outside of patient responsibility.
All right, well, thank you all very much for having us. Again, if you have questions, email them to us, and we put the answers on our Facebook page, which is also in the materials. Here's the clicker. Our materials will be posted on the foundation website, which is, who's got it off the top? LTCfoundation.org. So give us maybe 3 or 4 days, and all of our slides will be posted there.
Thank you.